Aloha, this is Professor Porter. We're discussing the Federal Rules of Evidence. In particular, we're in the middle of hearsay, and really we've gone through in other videos definitional hearsay under 801C, and essentially the rest of the coverage in hearsay. Most of the rest of the coverage in hearsay is not what the opponent says. The opponent's job is a familiar one. They have to say objection hearsay. They have to throw their hearsay flag in the middle of the ring and essentially start the evidentiary discussion that surrounds the hearsay objection. The options in this one are for the proponent that was likely on direct examination, asking questions of a witness, going to solicit some type of statement, maybe even an out-of-court statement, and then the objection came. And assuming we're over at sidebar, the proponent has a series of options. They have three pathways that you can see here by this introductory slide. First, because the opponent objects and says under 801C, objection hearsay, they're really saying this is a statement, it's out of court, and it's offered for the truth of the matter asserted. That is, it's offered for that bad purpose that's not allowed under the rules that makes it hearsay. So the first thing they could do with this far left panel as you're viewing this, the first thing the proponent can do is say, you say, yes, sir, you have this definition met, you have the foundational requirements of hearsay under 801C. I say, nuh-uh, you don't have it. You don't have definitional hearsay. Maybe it's not a statement. Maybe it's not out of court, or most popularly, it's not offered for that bad purpose. It's not offered for truth of the matter asserted. And there's some popular responses that you can have. If I'm the proponent and I'm responding, I would say, Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. Instead, it's offered for some other purpose, like impeachment, effect on the hearer, to go to knowledge or notice, and we go from there. Next, in a number of other videos, we talked about not hearsay or non-hearsay defined. Essentially, one rule away, 801D, one subpart away, where the definitional offerings are for the proponent. You may say objection hearsay as opponent, but as proponent, we're going to say, no, we have a not hearsay defined pathway under 801D. And really that involves these three areas. Statements against party opponents, that is when something is said by a party and offered by a party opponent, or attributed to a party and offered by a party opponent, or prior inconsistent statements that happen all the time, prior consistent statements that happen more rarely, at least they're available to the proponent more rarely, and then out-of-court IDs, when we have specific requirements for both of those pathways. And the last one, and I do think this comes in a checklist type format. Do I have a definitional argument under 801C, especially one that is, this is not offered, I'm not offering it as the proponent for truth of the matter asserted? Do I have a not hearsay defined under 801D? If I can make my way through those and I don't have anything to say, I don't have a credible argument as it relates to either of those definitional pathways, then I would proceed and only then proceed to the exceptions. And the first batch of exceptions that we talk about in the course and that most courses cover are those exceptions under 803. And really, I call these exceptions, these are like the reliability exceptions. We came up with, the rule makers came up with these exceptions because ordinarily we want firsthand testimony. We want to hear from the person with personal knowledge. We want to hear and meet the person at trial. That's for two reasons. We want the opponents to be able to cross-examine and ask follow-up questions of that person with firsthand knowledge, and we want the jury to be able to evaluate the credibility of that person with firsthand knowledge. That's why we have the hearsay rule. That's why 801C and this hearsay objection for the opponent is available to them. Well, there's rationale that goes with the exceptions too. These instances, these circumstances of these objections under 803, essentially the rule makers have said the circumstances by which this statement was said that's brought to court make it reliable enough, make it trustworthy enough. We're able to buy into the sincerity of the declarant enough. We don't need to meet them. We don't need the firsthand account as it relates to this quote. So if the circumstances are such that it meets the foundational requirements of an exception, the exception to the hearsay rules are foundational requirements for the proponent. The foundational requirements of the objection hearsay, of course, always belong to the opponent. So really what we're talking about here is there are foundational requirements for these many exceptions that are in 803 that we'll go through in separate videos. And in those foundational requirements, really the underlying policy, the underlying rationale by the rule makers is for the proponent introducing this statement through a witness declarant is likely not here, or the declarant need not be there. We're saying the circumstances of this statement and the content of this statement makes it reliable enough. So we've talked about essentially this top line in this chart, how it belongs to the opponent. And then, like we just discussed in the last slide, everything else belongs to the proponent. So we've talked about the definitional arguments that you can make under 801C. We've talked about the definitional arguments, the not hearsay arguments that you can make under 801D, prior statements offered against party opponents. I've offered some of my top rationale when something is not hearsay, not offered for the truth of the matter asserted. What would you say then? And next is the last thing that we can consider, the last topic that we can consider if we're serving as a proponent. Your Honor, might be hearsay, but an exception applies. And that is it. Here's what I say for each one of them. If I'm making a definitional argument, Your Honor, it's not hearsay. Maybe it's not a statement. Maybe it's not offered out of court, or maybe most popularly, it's not offered for the truth of the matter asserted. Instead, it's offered for. That's my response as the proponent if I'm making a definitional argument under 801C. If I'm making a definitional argument under 801D, Your Honor, this is not hearsay defined. It's a statement by a party opponent, or it's an out-of-court identification, or it's a prior inconsistent statement under 801D1, and I like becauses at either side to make sure you're getting your rationale out. Lastly, for our exceptions, it may be hearsay, but an exception applies. Specifically, this is a present sense impression under 803.1, an excited utterance under 803.2, a state of mind exception under 803.3, a statement made for purpose of medical diagnosis under 803.4. Whatever the 803 exception is, I like acknowledging, sure, opponent just said, objection hearsay. It might be hearsay, but an exception applies, and you narrow that discussion to the applicability of that exception that you're going to invoke. And of course, maybe there's more than one hearsay explanation. Maybe there's more than one exception that may apply. Here you see a slide. These are the major reliability exceptions, the major exceptions under 803 that most courses cover and that we spend the most time on. And I want you to think about it. We'll obviously have more detailed videos about what the exception goes through and working through a hearsay problem that invokes one of these exceptions. But I want you to think about the policy and the rationale behind each. Right? When you're going through them, don't lose sight of the fact that the rule makers looked at this scenario, looked at these circumstances where this out-of-court statement was said, and they said, well, in these circumstances, because of the uniqueness of these circumstances, we're going to consider this statement sort of reliable enough. It's not a guarantee of its trustworthiness. Certainly there can be misstatements and untruths that come out that still qualify for a hearsay exception under one of these 803 exceptions, but the circumstances make it reliable enough. Excited utterances, even though I hate the title of that, it's really just an exclamation that said real time or right after, an excited statement about something that has caused you to be excited and while you're still in that excited state. So there's 3 foundational requirements for the exception. Those foundational requirements belong to the proponent, as do the foundational requirements for all of these exceptions. And if they're met, and if the judge finds that they're met after the argument from both sides, because an exception applies, then the hearsay objection is going to be overruled and the evidence or the testimony is going to be allowed or admitted into evidence. So think about these patches when you go through them and when you're studying hearsay exceptions. The reason for these exceptions, because we decided that these circumstances and considering the circumstances surrounding the statement and even considering those words in the quotes in any type of hearsay analysis, when we look at the circumstances and look at the words and quotes, we've decided that this circumstance makes it reliable enough so we're able to let it in without meeting that declarant, without having firsthand testimony, without getting the benefit of cross-examination or the jury's ability to evaluate the credibility of that declarant. We might not get to meet them. They could be unknown to us, but the circumstances are reliable enough. Look out for further videos where we cover each of these exceptions.